myself. My name is Esther. I'm an attorney from Chugh law firm.
Thank you. Thank you for meeting with me.
Sure. So tell me your story and what I can help.
Yes. So my husband and I have been married for about 15 years. We have 3 kids. And since COVID and everything that's going on, I'm really afraid that I was wondering what we can do to protect my family. I heard something about trust or will. I don't even know if I need a trust. I don't have a lot of asset. I just have that house, 2 cars. What do you think?
Sure, it's really a good question, and first, I'm really glad to meet you here. But before we discuss more about details about what is living trust, so I would like to give a very brief introduction about how it works, what is living trust, and why we choose living trust and why we choose will. So, living trust is a separate legal document created by the individuals during their lifetime. So they're going to appoint somebody to manage the property for themselves or for the beneficiary, like their kids. So, for example, in your case, since you just mentioned you don't have a lot of assets and it's really straightforward, so what I would recommend is you and Homer can create a joint living trust, revocable living trust, and appoint your guys self as a trustee who manage the property. So which means that go ahead.
When you say revocable trust, what does that mean? Does that mean that I could change my mind and then take Homer out of the trust?
Sure, yeah, definitely. Revocable trust means that you can amend any, when you're alive, you can amend it anytime, you want and update it. So definitely, if you don't want that asset or if you want to sell it, you can just revoke it and amend it. So that's the reason it will be very flexible. So what you need to do is, you and Homer can create this joint living trust and appoint yourself as trustee who manage the property as the way you see fit, and just for your own benefits. And if one of you guys passes away, unfortunately, the surviving spouse will be the sole trustee who continue managing the property. And if both parties pass away, the successor trustee, so which means that you will appoint somebody to step in your shoe to distribute the property under that trust to your kids. So that's how living trust works. So the difference between the living trust and a will is it will be, goes effect right away when you execute it. But will only goes effect when upon the death. So that's the biggest difference.
So we don't have a lot of, like I said, we don't have a lot of assets, just that house pretty much. And when I die, I want it to go to the kids. And if I don't have a trust, isn't it already going to the kids?
Oh, it's a very good question. So definitely, if you don't have a trust, the house will still go to the kids. So there are another 2 options. One is will, if you have will, so which means that you can appoint somebody as executor and specify who will get the house. Right. The second one is if you don't have a will or you don't have a living trust, so which means the state and the court will decide who will get the property. So this is how it works.
So because the kids are still young and I do want it to go to them when we pass away, but what if we pass away tomorrow? Will my kids have all the money right away when I pass away when they're 10?
So it also depends. So for example, if you have a living trust, which means you appoint somebody, as a successor trustee. So what he will do is under that trust, under your instruction, he will take care of the kids. He will to decide, how much money will go to the kids. So, but if you want to, him to take care of the kids, so what will happen is he will be a trustee and distribute money, not as a lump sum, but will monthly go to kids and to take care of the kids reach certain year. So that's totally up to your decision.
So we can say when and how much, even though I won't be here anymore, I can dictate.
Yes, exactly. So, for example, for most of my clients, what they do is when both pass away, they will appoint, for example, grandparents will be the trustee who manage the property, and when the kids reach 18, he will get 25, and reach 22, will get another 25. So it all depends on how you want to arrange. But also some client would like to have a lump sum, which means that they don't want to, make it too complicated, so the kids will get all the money right away.
I see. Okay, and then what other documents do I need?
Sure. So for the whole package, what we call estate planning. So what we need is trust, revocable living trust, executed by you and Homer. Just what I just mentioned, how to distribute the money and what's the obligation, and then we will have a bill of sale and comprehensive transfer document, which just very document just saying I transferred all the property to the trust, and also we will have power of attorney. So this is also a document, for you if something bad happened, and you can appoint Homer to take care of you and to make the decision on behalf of you. So we will definitely go through all the details later.
Thank you. How much does it cost to write this trust?
Sure. So just based on, it also depends on cases by cases. So for example, in your case, I believe it should be very straightforward. So in that case, we just only charge a flat fee. But if some client want to highly customize, and then we will depend on what we need to do as additional.
That sounds really good. Thank you. How long will it take to draft this document and have it all set up?
Sure. So once I get the questionnaire from you, it only takes me 2 days to draft everything. But definitely, if there's some missing information, so I will leave it blank. So I'm gonna send the version to you, and we can discuss the next step. So for the first draft, it's only take 1 or 2 days for all of us to draft it. But for the next step and the discussion, definitely it takes some time because you need to fund the living trust. So which means that you also need to communicate with the bank, the other thing. But from our side, it's only 2 or 3 days.
Okay, thank you.
No problem.
So, what Esther and I just did was like the first visit for the initial consultation to set up a trust. A lot of clients are calling and asking, what happens if I die tomorrow? Where is my money going to go to? Where is my money going to go? Who's going to take care of the kids? What if I personally get disabled? Who's going to take care of me? Can my family support myself? And when I pass away, are there going to be disputes? Are the kids going to argue over assets? So the saying goes, there's only 2 things in life that's guaranteed: death and taxes. And estate planning helps prepare for both. For every trust, there are 3 different main parties. The settler is the person who creates the trust, and they take all their asset and put into the trust. The next person is the trustee. They're the person that manage the trust and look over the assets and make payments. Then the third party is the beneficiary. They're the one that receives the money. When you initially set up this trust, you could be all 3. So as long as you have the mental capacity and capability, you set up the trust, you're administering the trust, watching after the assets, and then you can take the asset and use it for your personal purpose. And so you're the beneficiary. When you pass away, you're still the settler because you created the trust, but you nominate somebody else to take care of the assets. And then you name people, like your kids, as the beneficiary. Esther, do you have anything to add?
No, I think it's 100% right. So, awesome.
So we went through the slide a little bit already. The trust is a legal entity. It's separate and it's apart from the creditor. Some clients set up trusts to protect from lawsuits because it's a separate entity. It's another layer that creditors have to go after. So there's different type of trust, revocable and irrevocable. We went through that. Living or testamentary. Living is when you started, it starts. Testamentary trust is in a will. Once you pass away, then the trust starts. Other types of trust, we could do it where the trustee is a private individual, or we can do it where the trustee is a corporate, like a business, a professional trustee. So the next slide talks about all the documents that we put together when we do estate planning for our clients. The main one, the one that we've been talking about today, is the trust. Then there's something called a pourable will. It's not the same thing as a will, but it pretty much says anything that I forgot to put in my trust, I want it to go into my trust. Then the next document is a healthcare directive. That's where you tell healthcare what you want to happen to your body, or when you're in the hospital. Like, do you want a do not resuscitate? Do you want to donate your organs? We also do that when we do estate planning. And the other document is for your power of finance, durable power of attorney. That's the document that takes over when you lose your mental capacity and you need someone to take care of your finances, like the company or the bank account.
Mm-hmm. So for the bill of sale, so what it do is it's a very brief paragraph, and it's specifically saying I transferred the tangible personal property to the trust. So basically, it's covered every tangible personal property you can name or you forgot to name in the Schedule A in the revocable trust. So for the comprehensive transfer document, like it explained very clear, which means that it's just it's more like a backup document to cover everything. So if not, forget, just certify that every assets I own has been transferred to trust. So the last one is certified deed. So this one I actually want to introduce a little bit because some of my clients, as I just mentioned, they don't want their trustee or successor trustee to know the detail of how much they have and what the property they have. So, but sometimes if you want to transfer the bank account, to the trust, so the bank needs to have a certificate of certificate deed, which means for the grant for the certificate. So which means that the bank will say, I don't need the detail, but I need somebody to certify that there is a valid and existence of trust. So this is certified trust. The last one is grant deed. So I just want to mention a little bit because the grant deed is the one we drafted to transfer the title from under personal per name to trust. So that will be filed within the county.
So we went through this a little bit. What's the difference between a trust and a will? A trust is effective immediately. It's actually a two-step process, but as soon as you sign it and then you fund it, it's good to go. A will is effective only when you die. Trust avoids probate. With a will, it's guaranteed you have to go through probate. Trust is private. Will is public. So a lot of times we spend time talking to our clients about who should manage their trusts after they pass away. So there's different train of thoughts on should it be an individual trustee or a corporate trustee. Esther, what are your thoughts on that?
So definitely I'm for individual trustee because most of our clients they have a very straightforward trust. So they have a very close relationship with the people they trust. So they will name them will name their friends, sibling, or parents as trustee. So and in some clauses in the trust, it also all depends on the discretion of trustee. So as an individual trustee, they will know what specifically the settler want. So I think that the individual trustee is more reliable and very convenient, and also definitely save the money because as a corporate trustee, they definitely need there's a fee for it. And if you don't have a lot of property and it is very convenient, you only have house and banking accounts, not very complicated, you can definitely save your money for it.
So with a corporate trustee, you do have to pay them a percentage of the asset, but this is what they do for their job, and it avoids family fighting because sometimes your son or daughter would have to talk to their aunt to get funds distributed, and there could be tension if the trustee doesn't want to release the funds. With the corporate trustee, this is what they do, and they know what they're doing. There's no tension or fighting with the family. We're pretty much done. Thank you, everybody. We appreciate your time.
All right. Thank you.